Good morning and welcome to the March 5th session of the Tennessee Court of Appeals at Nashville. We have 4 cases on this morning's docket. As a reminder, our arguments are streamed on the Tennessee Court's YouTube channel. I know there are at least a couple of cases involving minor children, and I know in each instance counsel will be sensitive to protecting their identities. We have read the briefs, so I'm sure that you can work around that. For appellants this morning, of course, arguments are 15 minutes per side. You can reserve up to 5 minutes for your rebuttal, so after introducing yourself to the court, if you'll make your request for your rebuttal time immediately thereafter, and then we will set the timer accordingly. Are there any preliminary matters from anyone before we get started this morning? Madam Clerk, if you'll call the first case, please.
Rosalynn Victor Addis versus Ryan Keith Addis.
We'll hear from the appellant.
Good morning. I'm attorney Wesley Clark. I represent the appellant Ryan Keith Addis of the Nashville Bar, and I would like to reserve 4 minutes of our time for rebuttal.
Very good.
So this is an appeal from a final decree in a divorce case where the parties were married for 16 years, but the story of the divorce really begins in about 2016 when Mr. and Mrs. Addis moved from California to Tennessee in search of economic opportunity. Now, that move was based on my client's thesis that Tennessee was a good spot for economic opportunity, both for the purchase of a piece of real estate for a marital home and also to get into a business deal where he could make some money to support his family through the acquisition of an insurance company. So once they get here, the deal falls through, but the home is purchased. So Mr. Addis continues to do what he's always done, and that is search for the next opportunity. Miss Addis is staying at home and raising the children, and during this next 3 years, the family begins to run low on funds. So by 2019, my client is in some pretty dire circumstances. The family's living on credit card debt, they have a negative net worth, and he finally secures a deal. And it's for a job in Ohio that's going to require him to move there. So he sets about accepting that job, and Miss Addis signs off on the incentive agreement that provides for these benefits for the family that require them to move from Tennessee to Ohio. And that was always part of the family plan, was to follow Mr. Addis for those economic opportunities. And so he gets to Ohio, but Miss Addis decides that she's had enough. She's not going to go along with the plan anymore. So she leaves him in Ohio while over that next year, COVID happens. In July of 2020, she files for divorce. And my client finds himself 500 miles away, unable to see his children, and with a moral and financial obligation to provide for his family. So, over the next 4 years that these divorce proceedings are pending, he pays for everything. He also increases the family's net worth by hundreds of thousands of dollars. The family's investment accounts go from being nearly zero to being worth over $300,000 at the time of divorce. All the while, he pays for over $300,000 of expenses for the family, including the lawyers for both sides in the divorce case. And by the time the final decree is entered, the court weaves a tapestry of erroneous assumptions that my client is basically a deadbeat dad, that he's willfully underemployed.
Is the trial judge viewing him as a deadbeat dad, or as he has an approach to how he likes to pursue jobs here? I think, isn't the trial court essentially saying that he has the capacity to work in years where he's reporting very limited income or no income? at a level significantly higher than that. Isn't that essentially what the trial judge is finding here? And your client has a pretty impressive skill set. It seems remarkable that he goes an entire year and makes no dollars in that year.
And that's a great point, Your Honor, because there are really two assumptions baked in there. And one is true. Yes, he could get a job, which he did twice during the pendency of the divorce proceedings, that, generated about $90,000 a year of annualized income. Now, both those jobs fell through for different reasons, but if he gets a regular good enough job, as the trial court characterized it, it's not going to be this six-figure income that he achieved only 4 years out of this 16-year marriage. In order to get those big payoffs, he had to leverage these business deals. These were not jobs that he went and applied for on LinkedIn or showed up at Verizon.
The trial court didn't seem to accept that argument, though, and the trial court seemed to think that he was quite capable of continuing to put together spreadsheets and identify business opportunities, at least, and if I'm misreading it, and let me know, but it seems like the trial court thought he could still get those types of jobs, but in the meantime, he should probably be making more than zero in terms of what he was capable of earning.
And that's another piece of that tapestry of fiction. My client, the IRS says my client made over $162,000 in 2023. My client presented bank records of deposits from companies and income from retirement accounts. That's $162,000 in 2023 that the IRS says that he made. But
the fact remains he did have those sort of home run years where he earned well into six figures. And when we're looking at this, we have to determine if we're going to overcome the presumption of the correctness of the trial court's findings. We have to say that the evidence is a greater convincing effect. And really, you're just arguing various facts, but really not that it's greater a convincing effect here, are you?
I would say that history is the best evidence we have here. And the history of Mr. Addis's income, no matter how you slice it, if you actually take a 4-year section of his income, which is reasonable, in order to generate those huge years, those home run years, there were some low earning years. If you slice 4 years out of any portion of his 16-year earning history during the marriage, you're not going to get the number the trial court arrived at by cherry picking 2 of the highest earning years. So it's either Mr. Addis should get a job.
Isn't that a reflection of the trial judge's judgment that it's unreasonable for him to essentially take a year and not work while looking for one of these home run opportunities?
I believe it's a reflection of the trial court's misunderstanding of the evidence, that Mr. Addis was not working. The evidence shows that Mr. Addis generated significant income to provide for his family by the wise investment strategies that he pursued.
Well, doesn't that argument, though, go against your position that the earning capacity was not established here? I mean, the fact that he could take the retirement accounts and generate a fair amount of income from that suggests to me that maybe the trial judge was right in its earning capacity determination here.
Well, that retirement income was reflected in Mr. Addis's tax returns. So if we're going to base his income off tax returns, then we should actually select a 4 or 5 year period to average that out, because it includes his income from all sources. And again, the trial court simply cherry-picked the 2 highest earning years. It would be like picking a golfer that won the PGA Tour twice in his lifetime and saying, you can win it every year. He'd love to, I'm sure, but Mr. Addis cannot.
One of the items that you fault the trial court here for is not fully appreciating the tax implications of the withdrawals from the retirement accounts. What sort of proof was presented on that issue to the court?
Excellent question, Your Honor. My client presented IRS publications, his own bank records, every single penny of transactions that were withdrawn from retirement accounts that went into his account for which he is liable. He presented a summary of that information. So that is all included in the, let's see, I don't have the number of that exhibit on my notes here, but I believe it's exhibit 30. But there are exhibits which specifically break down his tax liability, and not just a rough approximation, but also including every penny that he received from his employment and his tax brackets for the year
Well, one of the
2023.
arguments you've made is that trial court made a mistake as understanding that these gains would be capital gains, and therefore that would be the tax treatment. But it seems like to me that that mistake actually worked in your favor, does it not? Because if they were taxed as capital gains, the actual tax implication would be higher in this circumstance, would they not? Even with the 10% penalty, because otherwise it's ordinary income.
No, Your Honor. Long-term capital gains tax is lower rate than the income tax plus the 10% penalty. And I see we've got a limited time left, and I would also like to address the parenting plan issue.
Counsel, let me ask you about that. Why, how, is the appropriate standard here abuse of discretion in reviewing that determination with regard to the visiting in Nashville question?
Yes.
Why is it an abuse of discretion for short-term visits for the trial court to say those need to occur here in Nashville as opposed to in Louisiana?
It's a great question, Your Honor, because in the totality of this case, in the totality of this order, my client is ordered to perform at the highest level he's ever performed every single year economically, and also come to Nashville, 12 plus times, make these 1,000-mile road trips to exercise parenting time in a hotel room. I mean, it's unprecedented.
But not all of those instances, you say 12 plus times, not all of those instances are in Nashville, exercised in Nashville. You only have approximately, 4 to 5 of those periods of visitation that are confined to the Nashville area.
That's correct, but also that especially the July time period is going to fall during the week. So my client is ordered to just drop everything and travel 1,000 miles to stay in Nashville for several days. And it's unprecedented. There are no cases where this type of parenting plan has been ordered and appealed that I could find.
Isn't the alternative putting the kids in the car and having them drive 20 hours over a short time period? And dad's going or kids are going, somebody's going. So I'm trying to see why it's an abuse of the trial court's discretion for the trial judge to say dad goes rather than the kid spending 20 hours or flying.
It's all about the frequency. You're right. If it were just a difference between who's going, maybe it wouldn't be an abuse of discretion. But we are asking for a greatly reduced frequency of travel. It doesn't make sense to have this frequency of travel. We need to reduce the frequency.
All right. Thank you, Ms. Clark.
Thank
Your
you.
time has expired. We'll hear from you on rebuttal. We'll hear from the appellee. Mr. Caparella?
Good morning, Your Honors. Donald Caparella, Nashville Bar, along with Tyler Yarbrough, represent Rosalynn, Addis. I'd like to address this issue of the court not accepting husband's description of why he was voluntarily unemployed that you asked opposing counsel about. And there's a finding, I think, that is key to that. The trial court said, this is on page 349 of the technical record in her order, it appears to the court that this employment choice by husband has been some kind of strategy to gain an advantage in the divorce proceedings. And I think that just shows that in all the testimony of husband, the trial court came to that conclusion, which is essentially a credibility conclusion. And I just think that makes it really difficult to overcome the trial court's finding on that point. Also, this question of taxes, page 355 of the court's ruling, the court said, this had to do with the division of property. The court has essentially divided the marital estate in an equal fashion. While husband will have some tax consequences if he sells some of the investments, it still ends up being a 53% to wife and 47% husband division. So she calculated that if he's estimated, his estimation of $43,000 in tax implications for his income in 2023 is correct, and he was guessing because the tax year wasn't over and he hadn't filed his tax return, the court, even taking that into account, instead of it being a 50-50 property division, if you add in that 43,000, it switches it to 5347 to
So
the
was
wife.
there ever any testimony about the actual tax hit that would occur here for husband under this division of marital property?
He testified that his estimate of his tax implications for what happened in 2023 only was that it would cost about $43,000 in taxes when you add to it. But again, the court specifically addressed that and said the 50-50 split changes only slightly, even if you consider those tax implications, to 53 wife, 47 to husband, and that's not the kind of tweaking of a property division that this court should do.
Okay, so in terms of things that the court addressed, though, one of the things that concerns me is the wife's need here. And I know the argument you've made in your brief, putting together, based on the proof, how you would arrive at those factors. But typically we're used to seeing somewhere in the final decree itself some finding that I find the need to be X or Y. And we really don't have that here. Why isn't that a problem?
Well, it's a problem that can be handled by looking at the record, and the courts say that if it's readily ascertainable where the trial court got the wife's need and the overall abuse of discretion standard that's applicable to the issue of alimony, you can still affirm this verdict by doing the following analysis. The only number that is missing from the court's opinion is, well, the calculation is really easy to follow, is whether or not the wife's testimony and her affidavit of $7,171 in need is appropriate. That's Exhibit 14 of the record. The wife testified under oath that was it. And the other side never challenged any individual numbers in there.
And that number is inclusive of the need for the children as well, is that correct?
Yes.
Okay.
Yes.
Counsel, that number also, am I correct that number also includes refinancing, though, that didn't occur, and also attorney's fees that have already been paid? And is there about $1,000 of that $7,100 that essentially is dedicated to refinancing cost and also, or heightened cost, and also attorney's fees?
No, Your Honor, I'll address attorney's fees first. Exhibit 14 doesn't list $500 for attorney's fees. This is item S under expenses. It's the second page of the thing. What it says is legal/accounting/savings/retirement, $500. All four of those categories are listed at $500. And as it turned out, of course, she's had to have additional attorney's fees to handle this appeal. So that did come to terms. So their statement in their brief that she has $500 for attorney's fees is just simply not correct.
What about the refinancing?
Wife testified that she was going to refinance this if she got the home. And of course, the record can't include what's happened since. But she said she was going to refinance it, and if she refinanced it, the rates had gone up, and it was going to cost her another $340 a month to do it. So I can't tell you what's happened since then or what's going to happen, but
We know, though, that there was no order that required wife to refinance the home here.
no, but her testimony was that she was going to do it if she got the house, and she got the house. So it was reasonable for the court to consider that as not a speculative expense, but an expense that she was going to incur because she was going to refinance the house. So that $340 was appropriate for the court to accept. And they never specifically challenged any individual things. They just simply made their alternative estimate of what her expenses were. You have another question, Your Honor? Okay, so in terms of determining wife's need, you have, on one side, you have a essentially unrebutted affidavit of $7,171 backed up by her testimony, where they didn't attack any individual part, and you have an alternative argument that instead of using those numbers, which she testified were consistent with what the marriage was, they argued, let's look at the last 7 months of her expenses right before trial. The trial court And she testified, I was really struggling to make ends meet then. I was cutting way back on things. I wasn't taking any vacations anymore. I wasn't, going out to eat. I wasn't doing the normal things I was doing. And the trial court made an express finding accepting her testimony that she was not able to make ends meet during that period. So the trial court reasonably chose not to use the lower expense number that husband wanted to put her to. And more importantly, husband testified that his expenses were about $14,400 for him and his whole family. But he put an asterisk next to all the things that related to his family. So that left him with about $9,500 a month in expenses just for one person, while he wants to limit wife to $5,900 a month for 3 people. So I don't think that's a very good argument on that. So when the trial court is making a decision of need, there's only really one number that she specifically did not address, and that is the essentially unrebutted affidavit of the wife of $7,171 in need. And then after that, we have specific findings of $2,400 in potential income post-divorce for the wife, because remember, the trial court said that it's not desirable or appropriate for the wife to work full-time because she's got 2 minor children at home that she's homeschooling. And while the trial court did make a imputed finding of $35,000 a year because the wife had no really evidence of income for purposes of calculating child support, for alimony purposes, the court found $2,400 a month was what she could earn if she can get her real estate certification. Now, what's interesting about that is she testified she was making $25 an hour working for a real estate broker, helping with advertising, and that if she could get a real estate broker's license, she wouldn't be a real estate broker all of a sudden at 48 after being out of the market for 16 years. She would simply just be a better assistant for this real estate broker. So that license isn't going to suddenly make her a real estate broker that can practice independently. She's simply going to be a better assistant and make a little bit more money. So I'm sorry.
With regard to the home is under a mortgage, there's case law out of Tennessee suggesting you need a hold harmless provision, you need refinancing, that you're not going to keep the non-occupying party on the hook forever with regard to that mortgage. Are you suggesting there's something different about that case, that such case law wouldn't apply, or does that issue turn entirely on whether it's been waived or not?
Well, it was waived. However, if you were to order that the house be refinanced, I submit that by the time that this court's opinion comes out, that would have happened anyway. So that's not a big part of this appeal, I don't think, because it was always the wife's intent to refinance it, and I submit that will probably be done soon.
Well, I also wondered, though, because as you point out, we can't know what happened after the trial here,
Right.
or nor can we consider it. But as a remedy, could the appellate court modify the decree to provide that the spouse could hold the other spouse harmless in a case like this, where that sort of provision was left out?
You absolutely could. You could also order that be refinanced with
Well,
a
the
reason.
problem with refinance, though, as you point out, is if we order that and it's just been recently refinanced, I mean,
Well-
how do you deal with that? Do I have to go refinance it again? Whereas a hold harmless provision seems to take care of one of the problems.
That would be another solution, although usually if you refinance, you pay off the other mortgage anyway, so.
Right.
Yeah. So, but I think that's a solution to that problem, and I don't think that's really a big problem with this appeal, because I think it's going to be resolved either by this court or by the wife in a refinance.
Your
Yeah.
position, though, is that issue's been waived under Snead, that's not really before us appropriately in terms of the hold harmless or refinancing.
Right, because they didn't make any legal argument on that. Now, they did try and rehabilitate that a little bit on the reply brief, but I would submit that this court has held many times that that's too late to do that. So that leaves us with the other issue of the need. Another way of looking at this need. The trial court ordered $3,000 of alimony, rehabilitative alimony for 36 months, $2,000 of alimony for 60 months, and $1,500 of alimony for churro. So the first 3 years plus 5 years, which is 8 years, gets the children out of the home, or at least 8 to 18. Okay. And if, as we described, wife's need can easily be set at least $2,600 a month, which is just short of the $3,000 of alimony that the court ordered. And you can get, it's readily ascertainable if you just accept that the trial court heard essentially unrebutted affidavit at $7,100. Then you have, she's a little bit, the $2,600, you need to look at this rehabilitative alimony award as one award of 8 years, not 2 awards. One of $3,000, one of $2,000. It's really an 8-year award of $3,000 for 3 years, $2,000 for 5 years. One's a little bit more than her established need. One is a little bit less than her established need. But the one that's a little bit less is 60 months long. So if you look at it as one rehabilitative alimony award, then it's wife's demonstrated need that I think is readily ascertainable is right in the middle of that, maybe on the lower side, because again, for 60 months, she's going to only be getting $2,000 a month. So I think that's the best way to look at this, and that's why I think you should affirm the trial court's ruling on alimony, is because of the way the court broke it out into two different rehabilitative alimony rulings. Also, opposing counsel in their brief on page 41 essentially argued that whatever his income, whether it's the $250,000 to $2,000 that the trial court found or the $116,000 that he wants to argue over a 5-year period, he said that really only goes to the issue of child support, not alimony. He essentially said that husband has the ability to pay this award of alimony at either of those levels. It's interesting, he's arguing also that you should look at 2018 to 2022 as the 5 years for his, for the best determination of what his actual income should be imputed at, which averages out to $116,000. It's interesting that husband is leaving out 2023, where he claims he's working $162,000, but he's making $162,000, and therefore the trial court was wrong to find him voluntarily unemployed because he's earning $162,000 for his family. But the way he's earning it is he's pulling money out of retirement, which of course generates a taxable event, causing him to get income because he's pulling money out of retirement. So
Let me ask you a question
Yes.
about the alimony in futuro. What findings of the trial court specifically support the findings or support the award of the alimony in futuro? Because I believe it was set at $1,500 per month. What did the court find that supported that, or what factors did the court rely upon to justify the alimony in futuro award? I understand your argument on your rehabilitative alimony award, but what about the alimony in futuro?
the court found that there's no reasonable way that, given the fact that the wife had no college degree, had been out of work for 16 years, and had never had a substantial income ability, that she could in any way earn enough income that would be either comparable to the amount that of income that husband earned during the marriage, or that husband would likely earn after the marriage. So it really was just an assessment that a woman who's 48 years old, who has no education really, and hasn't worked in the workforce for 16 years, is no way going to match the either $116,000 or $252,000 a year income that the husband can. And of course, the statute requires this court to analyze alimony for churro on an abusive discretion standard review to determine whether or not she can meet either that test, the amount he could earn, the standard of living she had during the marriage, or the standard of living after. So the court made several findings comparing their educations and his earning history. That's how the court did that.
And how does that relate to, or how do you factor in the standard of living that she had during the marriage? Because it looks like it was pretty meager, what she had to do. She had to live very frugally during that time. So how much consideration did the trial court give to that?
Well, the trial court acknowledged exactly that point, that it was fairly frugal, but $1,500 a month is quite a bit less than $3,000 a month during the rehab period. And wife has reasonable expenses, I think, so the $1,500 would simply get her up to a reasonable level. It probably still even won't get her to where it needs to be. But there are very specific findings, some of which I just mentioned, when the trial court compared his work experience and also his employment, and also his education as compared to her, with her not being a college degree. And the cases they cited, all in, where the court reversed alimony in futuro, where it involved situations where usually the female spouse has a professional degree or a college degree or some clear work history. Here, the wife has no work history. She's essentially starting over after the children move out of the home. So I think that supports the trial court's ruling on alimony futuro.
Thank you.
All right, Ms. Kemper-Riley, time is up. I'm going to give you another quick opportunity to introduce your co-counsel. I know Ms. Yarborough, and I don't think your co-counsel this morning is Ms. Yarborough.
Because she wasn't here, I forgot her. I apologize. Tyler Yarborough is also co-counsel in this case, yes. Thank you.
Ms. Clark, we'll hear from you on rebuttal.
Thank you, Judge. First, I'd like to point out the portion of the record. It's Exhibit 48 through 52, and those are the IRS records and tax calculations by Mr. Addis regarding his income tax liability for 2023. Now, also, I'd like to direct the court's attention to the transcript of evidence 5, page 10, where Ms. Addis agrees that she lives a very frugal lifestyle, that she's lived a very frugal lifestyle from April to October, those 7 months of bank records that were just discussed. She agreed. Those were consistent with her standard of living during the marriage, and that's a very...
Didn't she say, though, that she wasn't getting the dryer repaired, she wasn't going out to eat, she wasn't going on vacation, and those things are things that she had done earlier in the marriage. So she's going over to the neighbors to dry the clothes instead of drying them at the house. I mean, is that really consistent with how she lived for most of the marriage?
That's what she said whenever she was asked to explain the additional expenses. She came up with a $50 amount that she received from a book sale, $100 for something else, but the amounts that are different were very small. And these parties met right before the financial crisis. They lived on a very low income from 2007 all the way up through Mr. Addis's first big lick in the mid-2010s. So the standard of living during this marriage is not set by maybe one high point where Mr. Addis has that really well-paying job and they're living a little better. Even in subsequent years, they accumulated that money and then spent it while he pursued the next opportunity. So again, the standard of living during the marriage was very frugal.
Ms. Clark, I know this is a somewhat minor point compared to the other issues, but I want to return to the refinance question here.
Yes.
I'm not sure I really understand the adverse impact on your client. In the brief, you seem to indicate that he really needs this refinancing to get himself off the mortgage because he needs that to be able to borrow new funds. But as I understood it, the way this business acquisition business worked is he got investors in, and the investors put money into the project. So he was putting his own funds into the projects as well to buy businesses?
Both things were true. I believe there were specific deals where he either put his own money in, or at least that was part of the plan, and then the plan fell through, like in the example of the insurance company here in Tennessee. So that credit worthiness is something he needs to be able to do. And
all right, and I know this is a separate issue as well, about you want them to be a certain time limit for financing, but what about the fix about us modifying the judgment to provide that the spouse would have to indemnify the other spouse or hold the other spouse harmless for any liability of the mortgage? Could you see any objection to appellate court doing that?
Your Honor, that would not solve the problem.
I appreciate that, but
Yeah.
if that is a remedy, though, do you see any problems with that remedy? I know you're saying it's not a full remedy for you.
Right. It would be a further impediment to my client's ability to earn this high level of income that he's got to keep afloat to pay all of his obligations. But aside from that, there's no legal argument against the court's authority to impose that as the appropriate remedy.
Right, that's what I want to know. Thank you.
And beyond that, just going back again to the rehabilitative and in futuro alimony, there is no need that justifies this level of alimony, and there is no finding that Miss Addis is incapable of rehabilitation. And there is evidence in the record regarding the earning ability of a real estate agent that Miss Addis is going to be capable of making, according to her own testimony. And that's Exhibit 61. It shows that the typical realtor is 61 years old and is a woman and has been a realtor for 11 years. So if Miss Addis started today, she would be the typical realtor in 11 years.
All right, thank you, Mr. Clark.
Thank you.
The case is submitted. We thank counsel for both sides. Mr. Mazine, thank you for being here this morning.
Thank you.
If we'll give them a moment to clear out here before we call the next case.